Well, hello students and welcome to the Week 5 lecture for LW305 for 2024. This week we're looking at customary and state law, and we're going to talk about statutes, custom and courts, a little bit about Pacific jurisprudence, and we're talking about culture and development. What I'm not going to do is go into a very deep dive into what is customary law or of the statutes and constitutional provisions around the region which establish mechanisms for recognizing custom or for custom as a completely separate plural legal system. You've studied all of that a number of times and you'll have other opportunities to do that. What I will say by way of getting started is that I really commend the topic guides and readings to you that are on Moodle for this course and for this topic in particular, because they do bring together all of the information you're going to need at this point in your life and your law studies on these sorts of topics. If you go out and you start practicing, land law somewhere, you're probably going to need to learn a lot more customary law relevant to land disputes or other areas, criminal law and sentencing, family law, etc. But for now, and for what we're looking at this week, is, I guess, the intersection of custom and state law. So what about this is a current development? Well, I guess the topic itself has been around for a very long time. Custom, development, custom law, state law, customary law, etc. But as an issue which affects the development of a country today in the Pacific, you better believe that the significance of this intersection of custom and law has only grown more significant and more important over time. So, you know about legal pluralism. You've studied things about that. That's where you have more than one system of laws operating within the same legal order, jurisdiction, place. You each live a life that's bounded by legal pluralities. You're a personal witness to the sometimes awkward balances or the symbiosis in which different power structures within society and different systems of duty and relationship come together and work together and sometimes clash. From last week's class, you know that the idea of legitimacy of a law or of a regulator or an authority is one of the most important ways of measuring the success of a set of rules imposed on any group of people, like our society. We as lawyers embrace that position, that we want our societies to be a society governed by rules. That is a fundamental choice of lawyers. Those rules, lawyers argue, should be binding equally on everybody. The law should be blind to race, wealth, and faith. What matters are the equal enforcement of rules and procedural justice, that the way rules are enforced is fair. Historically, even before Pacific Island countries were on the road to independence paved by the UN or by their own independence movements, customary law, its interpretation and its application were always closely interlinked with the development of Pacific societies. Customary leaders were responsible for leading their people towards what they hoped would be a peaceful and prosperous future. Really, the only way to do that was by working with foreigners who were militarily superior once Western influence reached the Pacific. These foreigners brought with them what was viewed as the gift of Christianity, and through technology, then boats, now telecommunications, now seafloor mining, brought not just the world to Pacific Island countries, but also brought Pacific Island countries to the world. people, places, customs, traditions, artifacts, bones that need to be repatriated. However, in embracing the world and its ideas and its systems, custom itself changed. Perhaps there are a few places deep in the highlands of Papua New Guinea where custom hasn't changed much in the last 100 years because there's been no contact, or deep in the Amazon. However, where we live in the Pacific, where you live in the Pacific, custom has changed over time. What we think of as governing our lives has changed over time. What would a Tongan living in the 1700s have viewed as the key things governing their life? What about somebody in Kiribati or in Nauru? What were those things that they thought governed their life? Or even before the 1700s, there might have been some early contact long ago. However, despite there having been change over time, those old ruling powers and authorities never stopped. They changed, they evolved as parallel power structures to state legal systems, or what we call now state legal systems. So on the one hand, we talk about custom as a separate system, but the reality is that even if you're a government employee, sitting in your office, doing your job, stamping some documents, those influences through custom or through family or whatever source still influence you and can influence your conduct, and that has implications for the way the whole of society operates. The veneer of parliamentary democracy and constitutionalism and the rule of law exist over a layer of power structures that influence the identity, the conduct, and the perceived options available to individuals in society. Without wishing to spoil the end of a good story, in a nutshell, where all of this thinking leads will be to the Guy Powell's Minimum Standards Framework, which we will cover in week 7. The framing we use is that the legal system and its laws must be responsive, understood, fair, effective, appropriate, and available. By that we mean laws need to reflect the places that they apply to. We, the people of the Constitution, we, the people, establish parliaments to make laws for us. The people need to understand what the law is if it's going to apply to them. To be viewed as legitimate, those the law applies to must view the law and the way it's applied as fair. It must be effective, and the laws must be appropriate to the needs of people. If you need the protection of law, it must be available. Otherwise, you'll stop relying on it. You might rely on your cousin who has a very big stick, or a gun. Why recognize the legal force of custom? Well, because it's already everywhere and it's already part of everything. Back in 1987, when Guy Powell was writing about law and custom in Pacific Island countries, if you haven't read what he wrote, you've probably got a lot of catching up to do if you're going to be a lawyer in your country, knowledgeable in law and knowledgeable in custom. There was a lot of work that was done by a lot of scholars who cared about exploring these ideas. So there's some older articles that are actually as relevant today as they were 30 to 40 years ago, and then there's a lot of stuff that we can critique for various reasons. As future lawyers, it's worth thinking about. You know what law is. You are part of culture. what components of what you think of as customary law or practices are law, and what components is a culture. Culture implies a social obligation. Law implies a legal obligation. If you're in Tonga and you were attending a formal event with the king, I would assume that you would wear mats or you would wear your most formal clothes. Well, what if you didn't? What if you wore ripped pants and flip-flops? Would there be social repercussions? Probably. You might get kicked out. Might get a clip over the ear from somebody. Would you call any of those social repercussions legal consequences? Perhaps. Perhaps you'd be chastened. It's not necessarily legal. Perhaps you'd be punished in some way by somebody. Perhaps you wouldn't be invited back. Well, should those consequences happen to you? Should they happen to a foreigner? Is the effect on you of having so breached that social norm, that mores, that custom, that practice, is the effect on you something that you would consider to be law? Or is it just culture, just something? But if it's not law, but it is the way that things are, and there are real consequences on you that you will avoid actively, to avoid those consequences, you will dress up, you will be there on time, then how can you separate that from some sort of state law, which has then a penalty for not wearing the right clothing? There might be that in Tonga, I'm not sure. There might have been once upon a time if there isn't now, and certainly there is in other parts of the world. So if you're then going to consider law reform, reforming state laws, making state law so that it fits into our society, well, it helps for you to know that this is a balancing act. It's always a balancing act. And there will always be winners and losers in every society. This is a consequence of our political system that theoretically gives equal weight to the rights and interests of each person, balanced against the public good or the public interest. Yes, you have absolute freedom to do whatever you want. Oh, but if you do that in a place where other people aren't doing that and are actually quite against that and might collectively act against you to prevent you from doing that there, then you can cry, "I'd like freedom," or you can go somewhere else that isn't there and do whatever it was you wanted to do, because those people are offended. And those people have given you a social consequence for being offensive. There's a lot more to unpack from the idea of public good and public interest, but we're going to move on. We might do it in other ways in other parts of the course. For those of you who, I don't know, lived through a recent global pandemic, there was a lot of stuff going on at that time around custom and public health, much in the same way as custom influences environmental policy and environmental laws, with traditional practices for the protection of reefs, estuaries, fish stocks, etc., and not the tuna populations. They're out on the border. We just occasionally get a payout from some fine Chinese fishing vessels or some Korean vessels, and that's fine. Just pillage the last sustainable, is it sustainable? The last non-collapsed tuna population in the world, in the Pacific. Let's go. Let's make it collapse. Yes. Go humans. Okay. So, by contrast then, if the government legislates something and nobody follows the law, to the point that the police don't even bother trying to enforce it, is whatever that is ever going to be seen as legitimate? Will that law ever have power if people don't allow the law to have power over them. It's all well and good to say that there are criminal laws and people will be prosecuted if they commit those crimes. But when you learn that less than 2% of reported cases of sexual assault or rape actually proceeds to prosecution, let alone conviction, does the law have power? Is there something wrong? Well, perhaps the more surprising thing is how many people do try to comply with the law, even when the law is inconvenient or confusing or not present. Do you know anyone of your friends, family, colleagues, anyone who's ever tried to get a driver's license or a passport? How easy was it and simple for you to enroll in USP? How simple was it for you to pay your fees on time and continue your studies? How easy is it for you to set up a stall at a market in the middle of town, or to start a legitimate business? How many forms, bits of paper, places do you have to go to? What a hassle. Why would you comply with all of that? Just 2 cashies in hand, right? Well, that's what a lot of people do. And then the government doesn't collect taxes because they don't make it easy to pay taxes. And then you get apps anyway, then you get scams. I have a lot of, I just want to say that the more you engage with the law, the more opportunities you have to feel tempted by the incentives to not comply. You know how little people look at this. No one will know. Especially if others around you are gaining an advantage over you by themselves not complying. Why wouldn't you just go with the flow? Be a sheep. Oh, well, it seems okay because they're all doing the wrong thing and it's fine, so I can do it. Or they put pressure on you. Just say yes. No, just sign this. Just sign that. No, just sign it. Hey, I'll tell your auntie. I've got many friends who are lawyers around the region. It's fascinating to see the variation for them in how deeply their obligations under custom impact their personal, professional and social lives. Some are driving back and forth to and from where they work to their village a couple of times a week. I have a colleague in Australia who has family in Fiji he's a family who is unwell, and he's travelled back and forth many times. I couldn't afford the flights. I don't know how him and extended family are able to pull together so that he can be back and forth to provide that support. But for some people, it is their life, and for others, it's much less so. But still, balancing attending family funerals or weddings or other things with court commitments is a big part of your life as a lawyer, and something you're going to have ethical questions that you need to answer regarding. You can read my thesis to find out more about that. When you become lawyers and you are practicing, you have a duty to your client to represent them and to basically get the best possible outcome for them. You also have a duty as a professional, and you swear an oath to uphold the laws of your country. Those are the state laws, because the judiciary is part of the state government. And when you become a lawyer and swear that oath, you become an officer of the court, which means you become an officer of the state. Are you following? You swear an oath on the Bible or an affirmation that you will uphold the laws of the state as an officer of the court. You're, in doing that, also probably someone who's considered increasingly important by your family. And depending on who your parents are, you might have some sort of chiefly title or some sort of other significant lineage, which comes with different duties and obligations which are parallel to and cut through the middle of everything else that you do. In many places in the region, the first steps for a defence lawyer will be to quickly try to resolve a dispute using custom. Much less hassle to avoid the scrutiny and institutions of law, convictions, problems, time, money. So at a deeper level, this helps preserve peace and prosperity of the community. It helps preserve social relations. It helps maintain the social fabric. At another level, it might sometimes result in injustice, just as the application of the laws of the state sometimes result in things we consider to be unjust. In the midst of all of that, as a lawyer, you're going to have to make some decisions around what is ethical. Currently, there's no material on this, no textbook. There's some court judgments. You'll always be able to seek advice from other lawyers and mentoring. But for many lawyers, navigating that ethical tightrope only occurs by feel. Within the criminal law and justice system, we see a tension between modernisation, custom, and state law constantly. It's often commented on in the media. We see rapists with reduced sentences due to successful pleas and mitigation, reducing their sentence for a combination of reasons. Early guilty pleas, genuine remorse, customary reparations. We each know that a negative consequence of customary reparations can be that rapists and people who beat their wives and children might get a lower sentence, or that might be coerced. The acceptance of an apology from a victim of crime could easily be coerced. So, in practice, what we end up with is a violent sexual predator living or released back into our communities sooner, or never imprisoned at all. Everybody then walks around with this sort of mental dissonance and knows that he is a bad guy, but that he is Wantok, he's family, he's a close relative. And people might feel deeply conflicted because you want to stay away from that guy. You want to keep your friends away from that guy. You want to keep your family away from that guy. This can give rise to some really tricky consequences, especially if instead of being charged, they're never investigated because they're a member of parliament or a big man or somebody else wielding significant power. You will have come across this term Pacific jurisprudence, and this slide has a great quote from Bernard Narakobi, who's a Papua New Guinean scholar of great repute. From before independence and ever since, there is a dream that some people have had. That is, that the laws of Pacific countries will one day be truly based on their own cultures, their own customs, and their own traditions. That's not to say let's reinvigorate cannibalism and eat all the foreign invaders, looking at you Fiji and PNG, or some sort of romanticized version of how things were in the past, but that a modern version of laws made by our governments and the common law in our courts might genuinely be based around an idea of law that is autochthonous, from here, ours, indigenous, homemade. The only way to get there is by constantly focusing on it and giving the idea time and attention, by accepting that the world is evolving. The idea that custom is static is completely false. We know it's changed over time to now. We know it's changed over the last decade or two. We know it will continue to change. No system is stable when it is static. It must change. And once we've accepted that the world is changing, we then have to start saying we need to accept that. We need to accept change, accept complexity, accept interactions. The next step forward should be in this direction. A good example of that is gender-based violence and domestic violence. How have these things changed over time? We have criminal laws against assault. We have criminal laws against rape. We have criminal laws against incest. We have, in many jurisdictions, new specific laws against domestic violence or against gender-based violence. And yet, according to the media, it seems to be happening more and more. Does that mean the law doesn't work? Does that mean the law doesn't actually reflect who we are as a people? Does that mean that despite change, there's nothing we can do about this problem? Well, it's probably not that bad. It probably means that the problem is much bigger than we realized. It also probably means that even if the law reflects our best values and represents the most beneficial parts of all of the collected views of people in society, our society includes bad elements, the yin and the yang. Sometimes we fail as people, parents, drivers, responsible adults, students, lecturers. Specific jurisprudence means that when you use a reasonable person test, you don't think about what would a reasonable man on the Clapham omnibus have done. Hopefully you remember that phrase from your earlier studies. If you remember your cases from criminal law, a reasonable person is a person on the Suva Express bus coming in from 8 Mile. A reasonable person is the person at the back of one of Samoa's party buses. A reasonable person is also the person that's probably sitting on their lap. In my opinion, it's a distorted fiction to say that in Pacific courts, custom and traditional norms are only considered in relation to adoption and land. I think that's a fiction. I mean, if it's the case, then we really have a problem. Magistrates and judges should be interpreting legal phrases such as an ordinary person or a vague phrase like the best interests of the child in accordance with local norms, local culture, and local ways of doing things. All of that in turn must be filtered through equity to give us justice. Equity, if you remember, come back to the correct slide. Equity, if you remember, is how we mitigate the harshness of the common law. It's why we put rapists in jail instead of spearing them or castrating them, which somehow still seems like a reasonable option to the man on the Suva Express. But for lawyers, we can see the long-term risk of state-sanctioned torture or state-sanctioned mutilation that could lead to a society that is more violent, not less violent. And then what if someone was wrongfully convicted? Which happens. Perhaps the problem in how slow development of Pacific jurisprudence has been is down to the experience of magistrates and judges. In Kiribati, there are only 4 maybe magistrates with law degrees: the chief registrar, the deputy chief registrar, and at least 1 senior magistrate. The rest are lay magistrates, although about 50, 60, maybe 100 now have qualifications from USP, a diploma in their certificate of justice, certificate program. So tell me, what do they know in depth about the common law rule about a reasonable person on the Clapham omnibus or on the local bus service? If a lawyer raised that before a magistrate in that hearing, would the magistrate even understand it? Would it need to be explained? Would something be lost in translation? Maybe, but also what does adhering to that weirdly constructed rule mean to them, that magistrate, in deciding that matter there and then? Nothing. You know, there's no buses in Abayang. There's no buses, I don't think, on Christmas Island. What if you've never seen a bus? Maybe in a film, but like, I'm talking about some pretty remote places at the moment. Maybe by now everyone's seen a phone or a TV and you've seen buses, but not live. There's a lot of things you might not have seen if you grew up on Christmas Island and didn't really travel much. So I think what you'll find in more provincial places is that where you have lay courts, lay magistrates, you have a shift the other direction. The standards, the rules and so on that are applied are more influenced by local customs and less influenced by, say, legal precedent. Do they make written judgments even? That's not good. That's not bad. That's just how it is. So, knowing the challenges as you do, what does that mean for law reform in your country? You're not from Kiribati. Well, if you are from Kiribati, hello. If you're not from Kiribati, well, what about your country? What does it mean for how a particular law should be? What does it mean for developing jurisprudence that applies to people from our country over time? How do you build that? How do you evolve those local rules into laws? The criminal laws around the region are the result of a white guy, or several of them, riding around, interviewing, well, swimming around, paddling around, sailing around, interviewing people, collecting information, writing dictionaries, and writing lists of criminal rules and laws and putting them into something which resembled a criminal code with a bunch of other stuff added from the English legal tradition. And so nominally, the criminal laws we have more or less line up with modern accepted custom and culture, don't they? When was the last time you checked that? I've never checked it. I'm not from there, wherever it is that you are. Unless you're from Australia, in which case, hello, but you're probably in the wrong class. What does that mean for developing things over time? Where do you imagine law will be in 50 years' time in your country? How do we go from now to what we imagine? What connects us? Will our current parliamentary leaders take us to that place? What is at stake in our society's governance? What maneuvering is taking place in traditional and customary circles of power? Who is influencing things in our society, in our state, public, civil society, from the inside? Who is influencing from the outside? China, the US, Australia, other interests, British American tobacco, Fiji water? What are their interests? Stability, peace, money? 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 I suppose that's more the corporations. I'm not sure if anybody else is really trying to squeeze the Pacific for money. What are they trying to get? Votes? Votes in the UN? As one enlightened student in LW305 in 2020 said, technology is always the first thing that changes, and everything else in society tries to adapt to that change in technology. Think about that one. Historically, the change in technology was weapons, steel, guns, cannons, forced big shifts in the Pacific, computers, other things, mobile phones. We're all trying to adapt and catch up to technology. Got some truth. This will always be true, and it will always result in adaptations that fundamentally change society. Just look at how many of you are using AI to write your forum posts and assist you in your assignments. A simple example of this is a refrigerator. If you've got no refrigerator, you don't keep much leftover food, or it goes to waste. Then we started to have ice deliveries. People would bring the ice, and then you put that in your ice box instead of a refrigerator. And maybe, depending where you grew up, you might remember kerosene fridges. Suddenly, we reveal a hidden social value behind the technology of keeping food cold. Now, if you have a refrigerator, it allows you to hoard food, which is really good for a pandemic, and really good if you've got a big family, and really good if you've got a lot of friends who come around and eat your food. Then once everybody has their own fridge, we realize that there's less communalism in the way that you gather, prepare, and share food. So something as simple as a refrigerator can result in wide-reaching social changes, especially combined with other technologies. People can just order food on their phone. Maybe you share a refrigerator with some other students and somebody eats your food. Now you've got no chicken for dinner and you're hungry. Suddenly, we have a new way for theft to occur as a result of our new technology refrigerators. However, if we foresaw the risk of stolen chicken and individuals hoarding food and getting fat and obese, would we have decided to ban refrigerators as a matter of government policy? Ban refrigeration? No, probably not. So even if a change has negative consequences, we can acknowledge that overall its benefit to society can outweigh the bad. Even if your housemate steals your chicken. Even if, people don't prepare food together as much. So to extend that example to law reform, we can never anticipate the full extent or consequences of changing the law or of introducing a new law. However, when we plan for the potential risks, honestly acknowledge problems that do occur, and we work to mitigate negative consequences for society through evidence-based policy, we're probably taking solid steps on a path to achieving our 2050 vision of what our society should look like, or our laws should be. So what is culture? Is it the same as custom? How would you describe them as distinct? How are the ideas connected? What is development? Is it always good? What about modernization? Are modern things better than traditional things? Fabric? What about modern diets? What about modern medicine? What do we know about development and culture? Well, they aren't always beneficial. One solution or one idea can create several new problems, and it can happen at different scales: local, provincial, regional development, local, provincial, regional culture. Just because something is new or different doesn't make it better. Just because modernization is inevitable doesn't mean we should rush to have every modern thing right now. Just because sea level rise seems difficult to deal with doesn't mean we shouldn't try. Just because a law isn't working properly and is causing harm in society doesn't mean that it is the first law we need to reform. We've got a long list of laws that might need reform. How do we prioritize them? For example, my favourite topic, reform of lawyer regulation in Pacific Island countries. Laws regulating lawyers will inevitably change. I will personally help catalyse it. However, is today the right time to trigger a 3-year review process in the wake of COVID? Maybe. Fiji started one last year. Where did it go? Why did it go wrong? Why did nobody ask me? Why did nobody talk to me? I've done the only review of Fiji's Legal Profession Act that's independent by anyone in the last 15 years. The only one in existence. Why didn't they just read my thesis? All right. I did do some consultations and liaison for that, but it seems to have died in the water a little bit. They perhaps rushed out their draft. So the slides talk about blending local ways with ideas to drive new approaches, but what about laws regarding building standards? If a government knows that houses built to a certain standard will survive a Category 5 cyclone, isn't the government being irresponsible by allowing people to build homes that aren't constructed to that high safety standard? We know that if they're built to that standard, that if they're not built to that standard, there's a big risk of death by cyclone. Then again, there are many ways other than making cyclone-proof buildings that people in Pacific Island countries have traditionally done to deal with cyclones over the last couple of thousand years. People living in villages know that if your corrugated iron sheeting blows away, once the wind dies down, you can go and find it, hopefully, and you can build another roof almost straight away. Whereas if the house is built out of bricks and tiles and it falls over, it's going to take you about 6 months just to clear the debris pile before you can even think about building a new house. Thus, there's a certain traditional wisdom in not constructing shelter out of something you can't rebuild quickly if it's destroyed, putting aside the cost. Still, at what point does the government become responsible for neglecting to enforce or introduce reforms that could save lives, like wearing seatbelts? At some point, it is best if the government has some sort of public consultation on the issue and gets feedback, whether through a law reform process, a policy development agenda, an election, or a round table, or some other mechanism. That way, if any decision they make, goes well or goes awry, it at least had the backing of the people. So, development and money. Development has an obvious link to money. If I'm the government and I only have $1 billion to allocate for everything, if I cannot say no to many good ideas, the country will be bankrupt next year. Right? So the first rule for government is saying no to things which are good ideas, let alone all the bad ideas. They'll really bankrupt you quickly. It's the good ideas that make sense that you can't afford. They're the ones that are really hard decisions. If money to fund all of this development that we need is limited inside the country, it has to come from outside the country. This is typically in the form of foreign assistance or as purpose-specific funding or as a generous loan. Another source for big dollar funding is corporations. Mining companies that will build a new power plant. Companies that will build roads or infrastructure which is then left behind, along with mine tailings, polluted rivers and a big hole in the ground. Ossetti mine, anybody? No? What about the endless stream of shipping vessels and oil tankers that seem to wash up on the reefs of Solomon Islands? Fiji and Samoan reefs seem to be better at attracting naval vessels than shipping vessels and oil tankers. Fiji's islands seem pretty adept at attracting cocaine, perhaps via Tonga, or as well as Tonga. Tourism operators building hotels, accessing remote attractions. Foreign companies interested in owning water supplies, electricity supplies, national airlines. But what happens if they go bankrupt? No airline. Who runs the power? Who runs the water? Fishing companies. It's very easy to tempt governments with the benefits of development. The temptation for most governments today is the promise of economic growth. As we know from watching the erosion of our shorelines, that a rising tide raises all ships. It also inundates coastal communities. But the principle of economic liberalism, the promise, is that economic growth, when it grows, everyone has more. The pie is bigger, everyone gets more pie. But what happens? Can we grow forever? Well, the sea levels will rise a finite amount, and then we'll make better decisions globally. Maybe when it affects more Western countries. Yuck. The global powers that fund and drive development have decided the best way for developing countries is to develop by growth. The economic basis is that if you've got a bigger pie to share, then there's more pie for healthcare or education or infrastructure. And that slice of that pie could be bigger than the entire pie that you started with before all of this growth. So it's a trade-off. Hopefully salaries keep pace with the cost of living. Have they? Will they always? Will they catch up? Will AI replace us all? Is that a good thing? We see good development, we see bad development. Does Suva need a giant half-built skyscraper? No, obviously. The school next door doesn't need it, nor the construction workers falling from it. I want you as students to not oppose, but question development. Instead of asking how much and where and what's in it for me, consider asking, do we need this? Do we need this here? Do we need this now? Sometimes development doesn't make sense. And just because you didn't accept it now doesn't mean you missed out. It means you've got a place right there that's ripe for development someday, but not now. For now, it's a beautiful park. So there are a number of quotes in the lecture slides from here from Siobhan MacDonald. There's some harsh truths, but also some hard edges in what you might read. So allow me to paraphrase. You are familiar with Bulla bubbles, countries swapping allegiance for Taiwan, from Taiwan for China and back. The huge numbers of foreign fishing boats just pilfering Pacific Island countries' territorial waters, or just on the edges of the territorial waters, on a global stage. The good, the bad. It is a fact of the world we live in that Pacific Island countries have very little power at all globally. Yet united, you can get to the United Nations. United, you can get to the International Court of Justice for a ruling on climate change. Little islands with small economies, small populations, no nuclear weapons or armies, mostly donated military equipment and vessels that pose a greater threat to the officers steering them than the illegal fishing boats that they were maybe pursuing, or drug traffickers. There's a big game being played out globally, and Pacific Island countries aren't invited to the party. They aren't even invited to the same table. Even Australia isn't at that table, the big global party table. New Zealand's not at that table, although they're middle powers. The world is run by big powers, which used to include Russia. It probably still includes people with nuclear weapons, but gee, it's really the US and China right now. India as well, I guess. And Pakistan, despite being a middle power, has their nukes. These big powers are playing big games, which make your own political leaders and big men dance. They're the ones seeking the money. They're the ones seeking the opportunities. And in turn, these men dance for each other. Trump dances for whoever's pulling his strings. Other electoral leaders seem to dance for whoever's pulling theirs. You can see the consequences of those games in the political decisions of your own leaders and wonder how such things happen. A few years ago, Fiji received 100 ambulances from China. That was in around 2019, 2020. It was before 2020. I don't think they were mobilized during COVID. When I last heard about them in 2019, they were sitting in a parking lot somewhere in the Western Division. They're literally, as far as I'm aware, still sitting in that parking lot. Maybe a few of them have been scrapped for parts. They can't use most of them, obviously, because they don't have 100 ambulance drivers. In fact, Fiji's probably only got a handful of ambulance drivers that are trained and qualified to do that. They're special vehicles. So that's a challenge. Also, the mechanics need to be trained to service them. A lot of fancy equipment with not a lot of English or Fijian language instructions running those ambulances. And that's just some ambulances. That's a pretty goodwill sort of thing. We've got solar systems, we've got stadiums, we've got roads, we've got ports, we've got all sorts of things. It's endless, right? So the point Siobhan McDonald is making is that if you're sitting in a Pacific country and you're saying, over here, we're an independent country, then you decide to use that as your starting point for making decisions, you'll end up having a bad time. Because at some point, there's always someone with more power sitting above us or sitting out of reach beyond us who can influence us. And I think we see that in the way that politics sometimes plays out. I mean, if on the other hand, apologies for the slide roll, if on the other hand, you accept that there is this global interconnected system and within a system, there are many, many complex relationships through which power and influence can be wielded, then you might be able to identify a better pathway forward than simply beating your chest and saying, well, I'm independent, so I'm doing this. You might find diplomatic solutions and options that you weren't aware of without more information, without starting from a different framing, without starting from a different perspective. I mean, why is that relevant to you in current developments in Pacific law? Well, all developments in Pacific law touch the issues that we discussed today. All development, custom and state law, is built on relationships. Social relationships, customary relationships, interpersonal relationships. The part of your brain that identifies self as something distinct from other and finds a way to relate to others, to your family, to your friends, to your classmates, to your colleagues, to your teachers, to your faith. Relationships between local and local governments with foreign donors and consultants. Relationships. That's the political reality that we exist in. In having a constitution and a government, are you operating as an independent country? Or are you operating as a country living with the ultimate triumph of colonial power and domination? What's the model of constitution? What's the model of statute? What's the brand of law? English common law, English legal tradition. England doesn't have a constitution, but Pacific constitutions are mostly modelled on a Westminster-style system, establishing parliamentary systems that resemble those that exist in most Commonwealth countries. Here you go. Here's your constitution by act of the British Parliament in some countries. Here are your old buildings. Hope you maintain them. Here's your new political masters and elite. They were educated overseas in our universities, and now they're your leaders. Now you're a state. Govern yourself. Have fun. Do you need help? We'll happily buy your power system. We'll happily buy your water plants. We'll happily buy your real estate. We'll happily buy your fishing rights. We'll happily buy your soil. We'll happily invest in your islands. And again, I'm saying this with a cynical note, but not all of that's been bad. Indigenous leadership hasn't, by any stretch of the imagination, been some negative thing that has resulted. Having a constitutional system, being governed by a rule of law, having lawyers hasn't necessarily all been a bad thing. It's been a lot of good things, we might say. We might even want to keep those ideas. But then how do we make them autochthonous? How do we ensure that they are our own? See, Pacific Island countries have quite a lot of strength to leverage through fishing rights, through the issue of climate change and climate action and so on. I don't think we need to start drumming up conspiracy theories and look for some hidden global agenda for the Pacific made from microchips and vaccines and whatever. But we have to accept that we exist in a global system. We aren't just one island. We're many islands. We aren't just one nation. We're many nations. We're a world composed of many nations. And we have to accept that these powers are rules-based orders. The states in which we live are rules-based orders. The United Nations is a rules-based order. International law is a rules-based order. Our constitutions establish rules-based orders. Our laws are rules and we are ruled and governed by them. Custom remains law. Custom remains sets of rules which govern us. Whether you think the current constitutional system is a version of social ordering that works best, or maybe that a traditional customary chiefly system would be a better rules-based order for you, is a completely personal decision. The reality is that whatever you think, the politicians you vote for aren't moving to change the way the current system is set up, because in the current system, they're sitting at the top of the tree. So again, who are your representatives, and are they representing you, and are they representing your interests? Or are they representing themselves? Why can't it be both? How can it be both? As future lawyers, you are personally becoming part of the rules-based order. The rule of law, literally, lawyer. Most of you think that by becoming lawyers, you're doing a good thing for society. Well, what if as a lawyer, you come across something happening that isn't good for society? A law that's not working, a policy that obviously can't work the way it's been articulated, an obvious statement by a politician that the government will do something that just simply isn't possible. Knowing what you know, knowing what your fellow citizens are perhaps ignorant of, what are you supposed to do? Well, I'm just going to leave you to contemplate where you think and where you feel all of that sits with you. Looking forward to seeing your discussions in the forums. Have a good week.